We will go on the record in the matter 23 CF 214, State of Wisconsin versus Bradley Scheuer. Oh, sorry, that's the 20. I'm not calling the new case.
Oh, you're not calling.
No, I'm only calling the, wait, you're right, the new case.
Do you want me to sit back in the?
Actually, no, you're right. I am only going to call the new case. And then I will call the old case after Mr. Davis excuses himself. So start anew. We will start afresh. We will go on the record in the matter 24 CF 202, State of Wisconsin versus Bradley Scheuer. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Scheuer in person in custody with counsel Nicholas Davis. We're set here today in this matter for a plea and sentencing. The parties have reached an agreement. Mr. Scheuer is currently in.
The Demeter battery charge might sound minor, but don't be fooled. Lurking behind this plea deal are far more serious allegations: false imprisonment and strangulation. Now, both sides get to make their case directly to the judge. No strings attached. Hook should judges have the power to toss plea deals aside entirely. Drop your thoughts below.
Custody facing revocation on another matter. Mr. Davis, what is the agreement that's been reached?
Your Honor, the agreement initially was reached with Attorney Renicky, and I believe that District Attorney Schmidt is going to go along with that same agreement. My client was going to plead to count 3, Your Honor, which is misdemeanor battery, and it was just for both sides free to argue on this case.
All righty. So both sides free to argue in 24 CF 202.
And I should say at that time, District Attorney Renicky, I know that he always would include dismiss and read in. So those other 2 are not dismissed outright, they're dismissed and read in.
That is correct. All right. So Mr. Schmidt, what is the basis for the public interest in reaching this agreement?
I think being free to argue on that misdemeanor is fair. I think the way the false imprisonment was described by the victim, it's a little iffy. The strangulations are always about the effect on the victim, so there's always come down to testimony. The battery is the thing that we can certainly do. So I think that doing that and arguing with the read-ins is appropriate. Thank you.
Victims' rights compliance.
A victim choosing not to speak, that's rare. Sometimes silence can echo louder than any testimony. Is it restraint, fear, or something far more complex? Whatever the reason, the absence of words tilts the courtroom's emotional weight back onto the defendant. Audience prompt: should victims be obligated to speak at sentencing?
Victim wish to make a statement? No statements made. All right. So, Mr. Scheuer, I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
Yes.
And that's the document that your attorney went over with you? Did your attorney go over it with you?
Yes.
Did he go over it thoroughly with you?
Yes.
Did he essentially go over it word for word?
Yes.
And do you understand everything on this document?
Yes.
And if you didn't understand something, did you have him explain it to you?
Yes.
And he did so?
Yes.
And is that your signature on the second page?
Yes.
So you are pleading guilty to 1 count of misdemeanor battery, is that correct?
Correct.
You are 66 years old, you have 12 years of schooling, you can read, write, and you understand the English language. Is that all correct? Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
You are not receiving treatment for a mental illness or disorder, and you've not had any drugs, alcohol, or other medications in the last 24 hours. Is that correct?
Well, I'm on heart meds, but
That's all.
Yes.
No medications that interfere with your ability to comprehend or understand?
No, I've been incarcerated for 6 months.
All right. And so, did your attorney go over?
6 months in custody and he hasn't even been sentenced yet. That's pre-trial detention in action. Sometimes the system punishes you before a conviction ever comes down. Legal insight, it's called time served. It can cut time off, your eventual sentence, or push you toward taking a plea just to get it over with.
With you, your constitutional rights?
Yes.
And did he go over them thoroughly with you?
Yes.
Do you understand them completely?
Yes.
You understand that you'll no longer have a trial, you'll no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will also no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand the rights that you're giving up here today?
Yes.
Now, do you also understand that if you're not a citizen of the United States, your plea could result in your deportation? If you're not.
Yeah, I'm a citizen.
I know, I have to ask that to everybody. Do you understand that the state would have to prove on or around September 6, 2024, in Burnett County, Wisconsin, you caused bodily harm to JEC by an act done with intent to cause bodily harm to that person without that person's consent, a Class A misdemeanor? Do you understand what the state would have to prove?
Yes.
Do you understand that upon conviction, you face a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes.
Do you understand that there is what's called a free to argue here? And that means that the state is free to argue for any sentence it feels is appropriate based upon the facts. Your attorney is free to argue any sentence that he and you feel is appropriate based upon the facts, but I'm not bound to follow either of those arguments or recommendations. Do you understand that?
Yes.
That I am free in my own discretion based upon the facts of the case, as well as the totality of the circumstances, your history, rehabilitative needs, etc., the community, to sentence you to what I believe would be an appropriate sentence. Do you understand that?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Now, did you go over the criminal complaint with your attorney?
Yes.
In particular, did you go over that probable cause section that basically says what happened and why you were charged with the crimes?
Yes, I read it, but I don't agree with it.
Well, and that's what I'm going to say. You may not agree with all of the facts 100%, but as it relates to this battery charge and the battery charge only, for those facts, are they essentially accurate?
No.
Well, I'm not taking his plea. We're going to go to trial because he's contesting it. He doesn't believe he did anything. We're going to trial.
Meltdown alerted. You catch that pivot? One moment he's swearing he's innocent, the next he's saying, fine, I admit it. That's not just nerves, that's a full-blown credibility collapse. And the judge, they can smell it from a mile away. Hook, ever seen someone fold that fast in court? Drop A if you've witnessed a courtroom meltdown before.
Okay, Mr. Davis, let's set the matter for trial. Then I'll move ahead and I'll sentence him on the other matter.
I agree. I understand what you're saying, but I do.
Nope, because you're not admitting to what you did.
Fine, I admit to it then.
Mr. Scheuer, I am not accepting a plea of an individual who is not going to be accountable and responsible for their actions, especially when it involves a battery to a person, a battery to a victim who did not deserve to have you put your hands upon them. Do you understand that? Yes. Now, if you're willing to accept that responsibility and admit to what you did, I will proceed and accept a plea. But if you are not, then we will go to trial. And I want you to tell the truth and be honest with what you did and your actions that day, or we will go to trial. I do not have any preference one way or another. I will not accept a plea if you are not guilty. I will allow you to attempt to prove your innocence or have the state prove your guilt beyond a reasonable doubt as to all of these charges to a jury. That is the justice system. So, Mr. Scheuer, I will again ask you, what did you do that day?
I put my hands on her.
You did. Did you? You put your hands on her.
That's what I'm charged with.
Yes.
Yes.
Did you put your hands?
Classic courtroom surgery. The judge walks him step by step through each element of battery, laying the groundwork for a solid plea. This isn't drama, it's precision. Legal breakdown. Battery equals intent plus harm plus no consent. She's verifying all three, one by one.
On her. Did you have a right to put your hands on her?
Yes.
You had a right to? The law says you can put your rights upon a person?
No.
Did you have a right to put
No.
your hands on her? Now, Mr. Scheuer, so you put your hands upon JEC, is that correct?
Yes.
Did she give you consent to do so?
No.
Did you have a right to do so?
No.
Did you cause her harm?
Yes.
What?
Yes, I said.
Yes, you caused her harm. Therefore, Mr. Scheuer, Are you guilty of battery?
Yes.
Now, with regards to the facts of the case as it relates to battery, did you review that with your attorney?
Yes.
Now, Mr. Scheuer, tell me right now, those facts as it relates to a misdemeanor battery, are they not 100% accurate, but are they for the most part as it relates to battery accurate?
Yes.
Are you telling the truth?
Yes.
Raise your hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Mr. Scheuer, are you telling the truth here today that the facts alleged in the criminal complaint as it relates to the misdemeanor battery are for the most part accurate?
Yes.
Are you stating here today that you in fact did lay your hands upon JEC?
Yes.
Are you stating here today that you in fact did not have consent to do so?
Yes.
Are you stating here today that you did in fact cause bodily harm?
Yes.
So, Mr. Scheuer, one last time, as it relates to the facts alleged in that criminal complaint, as it relates to battery, are they for the most part accurate?
Yes.
Mr. Davis, may the court use the probable cause section as well as the statements made under oath by your client to find a factual basis?
I think the court has made a solid record, so I would agree with the recitation the court had with the defendant. Thank you.
Thank you. Now, Mr. Scheuer, has anyone made any threats or any promises to you for you to plead guilty to this charge?
No.
You're doing so freely and intelligently. That means you, yourself, you're telling me that you fully understand what you're doing here today.
Yes.
And you're doing so voluntarily.
Yes.
Now, when I walked into court here today, you were making jokes, you were talking to your attorney, you were having a good time. So that's telling me that you like Mr. Davis.
Yes.
He's a good attorney.
Yeah.
He's a great attorney, actually.
Yeah.
He's a good guy, right?
Yeah.
You get along with him.
For the most part, yes.
Yes. Now, Mr. Davis, did he provide you at least competent representation?
I believe I provided him competent representation whenever he needed a question or a meeting or some kind of a phone conference that was provided to Bradley.
So, Mr. Scheuer, did your attorney provide you competent representation?
Yes.
Did he go over the facts of the case with you?
Yes.
Did he go over the facts of the case with you as it relates to the elements the state would have to prove?
Yes.
Did he go over with you the evidence and the discovery in this case?
Yes.
Did he go over whether or not you have any defenses or a lack of defenses in this case?
Yes.
Are you satisfied with his services?
Yes.
Now, Mr. Scheuer, do you have any questions for the court?
No.
Your Honor, may I say, just have one sidebar with my client?
You may.
Your Honor, I just want to make a record. My client, again, he's ready to proceed, and everything that he's put on the record is honest.
And for the record, I know you were talking to your client, but quite honestly, this is a courtroom. I have ears. I can hear very well. You were talking to him about his right to go to trial. He has the right to go to trial if he wishes to do so. That is his constitutional right, and he wishes to waive that right, and he wishes to enter this plea here today. Is that accurate and true, Mr. Davis?
It is. I just wanted to make sure one last time that if he wants to have a trial, I will make sure that I will represent him in that trial. And I said, well, and you will give him that access to that trial. And he said that he wants to go forward with his plea. I just wanted to double, triple, quadruple check on this.
And Mr. Davis, that's because you are a really good attorney, great attorney. He does his job very well, and he's very thorough. So thank you, Mr. Davis, for doing that. So is that all accurate and true, Mr. Scheuer?
Yes.
All right. So you wish to waive your right to a jury trial here today, and you wish to enter a plea. Is that correct?
Yes.
And Mr. Davis, based upon your conversations with Mr. Scheuer, do you believe he is freely, voluntarily, and intelligently entering a plea here today?
I know he is, Your Honor, yes.
And he understands what he is doing by waiving his constitutional rights?
Bradley is an intelligent man. He understands.
All right, then. Any questions before we proceed, Mr. Scheuer?
No.
As to count 3, battery, and a misdemeanor, how do you wish to plead? How do you wish to plead?
Huh?
How do you wish to plead?
I said guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis based upon your statements under oath